Partisan political divisions are the focus of a case the Supreme Court is going to hear on October 3rd. It's a case we talked about last week in a report from Wisconsin. Legal experts say the decision in this case could change the balance of power across the country. Two other states are in litigation, North Carolina and a state that's controlled by Democrats, Maryland. The question before the Supreme Court is this: is it okay for the political party in control of the state legislature to draw electoral maps that give an overwhelming advantage to their party? The plaintiffs in the Wisconsin case claim the Republican-controlled legislature drew the last set of maps to give the GOP an overwhelming advantage at the polls. They point to the maps used in the 2008 election compared to the one redrawn by GOP leaders after the 2010 census and used in the 2016 election. Today, we're presenting the two arguments that the court will hear. Wisconsin Attorney General Brad Schimel for the state of Wisconsin and Jerry Hebert with the Campaign Legal Center representing the plaintiffs. I've asked both men to outline and argue their case for me. Mr. Schimel, why don't you start for me? Tell me the case that you're going to be presenting on behalf of the state.
Well, there are a number of things that we're presenting. First, that the legislature in Wisconsin actually followed the traditional redistricting principles. They looked to keep the districts compact. They followed the rules for contiguousness. They followed population equity, and they avoided splitting up municipal boundaries. The Supreme Court has in the past accepted that redistricting is a political process and that winning elections leaves you able to draw the maps, and that they're not going to be perfect. One of the factors in Wisconsin that makes a big difference here is just the demographics, where voters are packed. In Milwaukee County and Dane County, where Madison is, we have huge percentages of Democratic voters, and they're clustered very tightly together. You have other places like Waukesha County or Washington County where you have the opposite, Republican voters. There's variances around the state, but it's primarily those big population areas like that where people are really clustered, and it's hard to break them up. So you're not ever going to be able to get a perfect mix. But the plaintiffs they won't say this outright, but they're really seeming to claim that there's some constitutional right to proportional representation of political parties, and the Supreme Court's never accepted that.
Mr. Hebert, walk me through the case that you're going to present.
So we filed a lawsuit in 2015 challenging the Wisconsin assembly districts, the state house there, 99 districts. About a third of them are represented by Democrats. And we argued that, made a claim that the redistricting plan that they did in 2011 was a partisan gerrymander designed with the intent and the effect of minimizing the minority party, in this case the Democratic Party, vote throughout the state. We argued it violated the First Amendment and the 14th Amendment, and we won in the lower court. First time in 31 years that a federal court has declared a partisan gerrymander unconstitutional. Technology today is so sophisticated and the partisan divide so extreme that what we see is that people entrench themselves in power in ways through cracking and packing of districts unlike anything we've ever seen in our nation's history. It's so incredibly detailed and with surgical-like precision that people can draw districts to ensure who's going to win in subsequent elections throughout the entire decade.